Crime and punishment. The death penalty in Texas. In Texas, the district courts have original jurisdiction over all criminal felony cases. If an individual is convicted of a capital felony, he or she may be subject to punishment by death. A capital felony is one in which an individual intentionally or knowingly causes the death of an individual under special circumstances. Criminal homicide is when someone intentionally, knowingly, recklessly, or with criminal negligence causes the death of an individual. Murder is when someone intentionally or knowingly causes the death of an individual or intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual, or commits or attempts to commit a felony other than manslaughter, and in the course of and in furtherance of the commission or attempt, or an immediate flight from the commission or attempt, he commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. The following are different types of capital felonies: the murder of a police officer or fireman, murder during the commission of a felony, murder for hire or pay, murder by an incarcerated person, murder of more than one person, the murder of a child, or retaliation against a judge. Texas has the law of parties, which allows offenders to be sentenced to death if present while a capital crime is being committed, based on the offender being criminally responsible for the conduct of another. Kenneth Foster Jr., pictured here, was sentenced to death under Texas's law of parties, which deemed him just as responsible for the murders as those who pulled the trigger. He was originally sentenced to death for his role in the murder of Michael LaHood in San Antonio in 1966. Foster had not killed LaHood, but was instead the getaway driver in a string of robberies, The trigger man, Mauricio Brown, was executed in 2006. Governor Rick Perry commuted the sentence of Kenneth Foster Jr. to life, just hours before his scheduled execution in 2007. Appeals. After the verdict is rendered, if the defendant is found guilty, the case is automatically appealed to the Texas Court of Criminal Appeals. If the prisoner loses in the Court of Criminal Appeals, he or she may then appeal the case to the U.S. Circuit Court of Appeals, and then finally to the United States Supreme Court. This is a picture of Thomas Whitaker, who was 23, when he set up a fake burglary at his family's home in order to have his parents and younger brother killed in hopes of collecting a $1 million inheritance. Only his father survived the attack. On the right, you see a picture of his father, Kent Whitaker, upon hearing that the parole board had recommended to change his son's sentence to life in prison. When the entire appeals process has been exhausted, the governor of Texas still may have a limited power to grant clemency to the prisoner. In capital cases, the governor has the constitutional authority to grant an offender one 30-day reprieve of a scheduled execution without a recommendation from the Texas Board of Pardons and Paroles. Upon recommendation from the board, the governor may grant one or more reprieves in a capital case. If the prisoner submits a timely request for a reprieve of execution, the board must determine, by majority vote, whether to recommend to the governor that a reprieve be granted. If a death row inmate files a timely petition to the board for a commutation of sentence to a lesser punishment, such as life imprisonment, the board will vote on whether to recommend the commutation to the governor. In 2018, the Texas Board of Pardons and Paroles voted unanimously to recommend clemency for death row inmate Thomas Whitaker facing execution. Governor Greg Abbott, a Republican, approved the recommendation to change Whitaker's death sentence to life in prison. The last time the board recommended The last time that the board had recommended clemency for a death row inmate was 2009, and a Texas governor had not approved clemency since 2007. The Texas governor cannot impose a moratorium on executions, as this authority is not allowed in the Texas Constitution. To give the governor this power would require a constitutional amendment approved by voters. The governor has clemency authority on the advice of the Board of Pardons and Paroles and needs a favorable recommendation from the board in order to be able to grant clemency. The governor is not obligated to follow the recommendation of the board, however. The governor also has the power to grant a one-time 30-day reprieve. The governor appoints the members of the Board of Pardons and Paroles. Between 1819 and 1923, Texas executed its death row prisoners by hanging. Hangings were administered by the county where the trial took place. In 1923, Texas required that executions be carried out on the electric chair and that they take place at the Texas State Penitentiary at Huntsville, also known as the Huntsville Unit. In 1977, execution by lethal injection became the legal method of enacting the death penalty in Texas. The first prisoner executed by lethal injection in the United States took place in Texas in 1982. The United States Supreme Court decision in Furman v. Georgia declared Georgia's unitary trial procedure, in which the jury was asked to return a verdict of guilt or innocence and simultaneously determine whether the defendant would be punished by death or life imprisonment, to be unconstitutional on the grounds that it was a cruel and unusual punishment in violation of the Eighth Amendment to the United States Constitution. The ruling essentially negated all death penalty sentences nationwide. It led to a 1973 revision of the Texas laws, introducing a bifurcated trial process where the guilt, innocence, and punishment phases are separate, and narrowly limiting the legal definition of capital murder. As a result of the Furman decision, the 52 Texas death row inmates at the time had all of their sentences reduced to life imprisonment. One of them was Kenneth McDuff, who was originally condemned for the murder of 3 teenagers in 1966. He was paroled in 1989, but subsequently executed in 1998 for a murder he committed while on parole, and he is suspected to have been responsible for many other killings. Jerry Jurek was convicted of killing 10-year-old Wendy Adams in 1973. His case went to the Supreme Court as one of several testing new death penalty laws around the country. The Supreme Court decision in Jurek v. Texas once again allowed for the death penalty to be imposed. The first execution in Texas after the Jurek decision was on December 7, 1982. In the post-Gregg era, Texas has executed 576 people. By 2021, the usage of the death penalty in Texas courts was on the decline. There were 3 executions in 2020, the smallest number of executions per year since 1996, which also had 3. In 2020, 2 persons were sentenced to death, making it the post-1974 year with the lowest number of people sentenced to death. In September 2005, Texas implemented life without parole sentencing in capital cases. Prior to that, juries had a choice between the death penalty and life in prison with a possibility of parole after 40 years. Texas is first in the number of executions carried out in the United States since 1976. Texas, the second most populous state of the Union, has executed 576 offenders since capital punishment resumed in 1976, beginning in 1982 with the Charles Brooks execution. Texas was the first U.S. state to carry out an execution by lethal injection, executing Charles Brooks on December 7, 1982. One Texas county, Harris County, accounts for over 280 death sentences and 127 executions since 1982. You can see Harris County in the dark blue here on these maps, and see that it is a leader in imposing the death sentences in Texas over the last 5 and 10 years. "13 juveniles were executed in Texas before the 2005 U.S. Supreme Court decision in Roper v. Simmons. The Supreme Court drew the line at age 18 in death cases after the death sentence was given to a 17-year-old Christopher Simmons, who had kidnapped a neighbor in Missouri, hogtied her, and threw her off of a bridge. Prosecutors said he planned the burglary and killing of Shirley Crook in 1993 and bragged that he could get away with it because of his age. 29 juveniles awaiting execution were sentenced to life in prison and removed from death row in response to the decision. The U.S. Supreme Court prohibited the application of the death penalty to persons with mental retardation in a different case, Atkins versus Virginia, in 2002. But the Texas legislature still has not enacted statutory provisions governing the standards and procedures to be followed in those cases. As you can see by these tables, the person who holds the record for the shortest time on death row prior to execution in the modern post-1982 death penalty in Texas, that person is Joe Gonzalez, who was only on death row for 252 days before his execution. The person with the longest time on death row is David Lee Powell from Travis County, who was on death row for 31 years before finally being executed in 2010. Carla Faye Tucker was convicted of murder in Texas in 1984 and put to death in 1998. She was the first woman to be executed in the United States since 1984 and the first in Texas since 1863. She was sentenced to death for killing 2 people with a pickaxe during a burglary. Tucker, who was 21 at the time, and her boyfriend Danny Garrett, who was 35, entered the apartment of Jerry Dean in Houston, Texas, around 3 a.m. in 1983 to steal a motorcycle that Dean was restoring there. During the burglary, Tucker and Garrett entered Dean's bedroom, where Tucker sat on him. To protect himself, Dean grabbed Tucker above the elbows, and Garrett struck Dean several times in the back of the head with a hammer that he found lying on the floor. After hitting Dean, Garrett left the room to carry motorcycle parts out of the apartment. Tucker remained in the room. The blows that Garrett had dealt Dean on the head caused him to begin making a gurgling sound. Tucker, saying afterwards that she wanted to stop him from making that noise, picked up a 3-foot pickaxe that was lying against the wall and began hitting Dean. Garrett re-entered the room and dealt Dean a final blow in the chest. Garrett then left the room again to continue loading motorcycle parts into his car. Tucker was once again left in the room, and she noticed a woman who had hidden under the bed covers against the wall. The woman had spent the night with Dean, but had hid when Tucker and Garrett broke into the apartment. Upon discovering the woman, Tucker attacked her with the pickaxe. She and Tucker began to struggle, but Garrett returned and separated them, and then Tucker began hitting the woman repeatedly with a pickaxe until it was embedded in her heart. The next morning, one of Dean's co-workers discovered the victims' bodies. Tucker and Garrett were arrested about 5 weeks later. This case, concerning Cameron Todd Willingham, is often cited as one of the most likely cases in which Texas might have executed an innocent man. Todd Willingham was executed in 2004 for arson in a 1991 house fire that killed his 3 daughters. The arson theories used as evidence in his case have since been repudiated by scientific advances, and arson experts now believe the fire was accidental. Anthony Graves spent 16 years in prison before being released on October 27, 2010. He was convicted based on the testimony of Robert Carter, a murderer, who said Graves was his accomplice. 2 weeks before Carter was scheduled to be executed in 2000, he provided a statement saying he had lied about Graves' involvement in the crime. He repeated that statement a few minutes before his execution. Graves' conviction was overturned in 2006 due to prosecutorial misconduct, and the special prosecutor assigned to his new trial dropped the charges against him, saying, "We found not one piece of credible evidence that links Anthony Graves to the commission of this capital murder. He is an innocent man." Randall Dale Adams was convicted and sentenced to death in 1976 for the killing of a Dallas police officer named Robert W. Wood. In October 1976, 27-year-old Adams and his brother left Ohio for California. En route, they arrived in Dallas on Thanksgiving night. The next morning, Adams was offered a contracting job. On the following Saturday, November 27, Adams went to start work, but no one turned up because it was a weekend. On his way home, his car ran out of gas. David Ray Harris, who had just turned 16, passed Adams in a car that he had stolen from his neighbor in Vidor, Texas, before driving to Dallas with his father's pistol and a shotgun. Harris offered Adams a ride. The two spent the day together drinking alcohol and smoking marijuana. That evening, they went to a drive-in movie. Shortly after midnight on November 28, Dallas police officer Robert W. Wood stopped Harris's stolen car because the car's headlights were not on. As Wood approached, he was shot twice in the forearm and chest by someone in the car. The vehicle sped off almost immediately after the shooting, giving Wood's partner, Teresa Turco, little time to react. She later testified that she managed to fire upon the fleeing vehicle, but to no avail. After returning to Vidor, David Ray Harris boasted to friends that he was responsible for the crime. Harris was arrested, but when he was interviewed by police, he accused Adams of the murder. Harris led police to the car driven from the scene of the crime, as well as to a .22 caliber revolver he identified as the murder weapon. Dallas prosecutor Douglas D. Mulder charged Adams with the crime, despite the evidence against Harris, apparently because Harris was a juvenile at the time and Adams, as an adult, could be sentenced to death under Texas law. Adams testified that Harris had dropped Adams off at his motel, where Adams and his brother watched TV and then went to sleep. He claimed he was not in the car when the shooting happened. Harris testified that Adams was not only in the car, but was the driver, as well as the shooter of Officer Wood. Testimony by Harris and several questionable eyewitnesses, including Emily Miller and R.L. Miller, who claimed to have driven past Harris's stopped vehicle immediately before the shooting, led to Adams's conviction. Texas forensic psychiatrist James Grigson, nicknamed Dr. Death, was also a witness for the prosecution. Having conducted a psychiatric evaluation of Adams, he told the jury that Adams would be an ongoing menace if kept alive. As a result of this testimony, Adams was given the death penalty. His conviction was unanimously upheld by the Texas Courts of Appeals in 1979. In 1995, Grigson was expelled from the American Psychiatric Association and the Texas Society of Psychiatric Physicians for unethical conduct relating to expert witness testimony. Adams's execution was originally scheduled for May 8, 1979, but U.S. Supreme Court Justice Lewis F. Powell, Jr. ordered a stay 3 days before the scheduled date. In 1980, the Supreme Court, on an 8-1 vote, ruled unconstitutional a Texas requirement for jurors to swear an oath that the mandatory imposition of a death sentence would not interfere with the consideration of factual matters such as guilt or innocence during a trial. As a result of the decision, Adams's death sentence was reversed, and the Texas Court of Criminal Appeals granted him a new trial. Before the trial could begin, however, Texas Governor Bill Clements commuted Adams's sentence to life in prison at the request of the Dallas County District Attorney. In May 1988, David Ray Harris, now also a prisoner on death row, admitted that Adams was not even in the car on the night of the murder. In August 1988, a documentary film, The Thin Blue Line, detailed many inconsistencies in the prosecution's case, further casting doubt on Adams's guilt. In 1989, the Texas Court of Criminal Appeals overturned Adams's conviction on the grounds of malfeasance by the prosecutor, Douglas Mulder, and inconsistencies in the testimony of a key witness, Emily Miller. The appeals court found that prosecutor Mulder withheld a statement by Emily Miller to the police that cast doubt on her credibility and also allowed her to give perjured testimony. Furthermore, the court found that after Adams's attorney discovered the statement late in Adams's trial, Mulder falsely told the court that he did not know the witness's whereabouts. The Texas Court of Criminal Appeals stated that the conviction was unfair, mainly because of prosecutor Doug Mulder. Following the appeals court decision, the district attorney's office decided not to prosecute the case again, and Adams was released. Despite being wrongly imprisoned for 12 years, Adams received no compensation from the state of Texas. At the time his conviction was thrown out, wrongly convicted prisoners could get a lump sum payment of $25,000 if pardoned by the governor. However, since Adams was released because his case was dismissed, and not because he was pardoned, he received no payment from the state after his release. If Adams had been found to be wrongly convicted under present-day Texas law, he would be entitled to receive $80,000 for each year of incarceration. Adams later worked as an anti-death penalty activist. He wrote a book about his story, Adams versus Texas, which was published in June 1992. In 2001, at an anti-death penalty legislative hearing on behalf of the Texas Moratorium Network, Adams said, "The man you see before you is here by the grace of God. The fact that it took 12.5 years in a movie to prove my innocence should scare the hell out of everyone in this room, and if it doesn't, then that scares the hell out of me." Adams died of a brain tumor in Ohio in 2010 at the age of 61.